Welcome everybody. Thank you for attending this webinar. My name is Debbie Farman, Director of Jordan's Group of Companies, MD and Jordan's Corporate Law, a law firm authorised and regulated by the Solicitors Regulation Authority. My co-host today is Karina James Wiltshire, a Chartered Legal Executive in the Corporate Technical Team in Jordan's Corporate Law. Jordan's Group is now part of Vistra, a global corporate service provider. This webinar is designed with a director of a UK company in mind, and our purpose is to provide an informed webinar to help directors of UK companies stay on top of their duties and obligations. It's designed to provide awareness of the current legislation and best practice guidance, this to help equip a UK director with the knowledge to manage and protect their business effectively. So what we want to cover today is, from a director perspective, what your duties are and where you find detailed information about your obligations, how to effectively manage and protect your business by ensuring compliance, how to build a strong corporate governance framework to gain and maintain your trust of your stakeholders and to properly exercise your duties as director. We will also take the opportunity to look in detail at Section 172 of the Companies Act and the proposed changes and how to comply with those changes. And then we'll give you some practical steps to stay on top of those duties. And if you're still excited at that point, then you can sign up for a free fact sheet to use for all new directors, which we'll be providing to those who would like that. We've set an hour for the webinar. If technology allows, you have the opportunity to ask questions as we move through the hour. We will answer these at the end, and you'll also have the opportunity to contact us after the webinar, should you wish to do so.
Okay, so as you can see there's a photo of the Shard, and we've chosen this image because since 2010, it's been the tallest building in the UK. So we thought this was apt to use as a visual to focus our minds on staying on top of your director's obligations.
So before we look at the codified duties, it is usually helpful to explain how these duties came to be the main elements of the legislation. English law is derived from common law, which means that the law has evolved from custom and judicial precedent rather than statute. The overarching duty of a director is to manage the company for the benefit of its shareholders. The main common law duties prior to the codification in the Companies Act 2006 were to act in good faith in the best interests of the company, not to make a secret profit, to act with skill and care, to act at all times in confidence, so in essence to maintain confidentiality. And the Constitution, the company's constitutions through the years, has confirmed that the duties of a director is owed to the company. Should they breach that duty, shareholders could bring an action against them for breach. To demonstrate the layering of case law to achieve judicial precedent, we've noted a couple of cases on the slides. You'll see that the first being Cook and Deeks and the second being Re Jean. The first, just going into a little bit of detail, was in relation, in 1916 case, remained good law all the way through to codification. It involved directors of a construction company negotiating a contract with the Canadian Pacific Railway. The majority of directors decided that the contract was not viable for the company, But Deek, along with another director, Hines, took the contract on with a different company. They actually set up that company during the negotiation for the work, encouraged the other company to decline the work. So the conclusion of that case was that the director is not at liberty to sacrifice the interests which they are bound to protect. And actually the outcome of that was that the profits made on the contractual opportunity were to be held on trust for the original company. The second case deals with fire. A fire decimated a business despite the director instructing their insurance broker to include coverage of fire as an insurance risk. It was missed off the paperwork. So even though the director had pulled in an expert there, actually there was a simple knot added to the documentation which the judge felt the director should have picked up if the director had read the paperwork with skill and care. So that really is, again, still good law, even though we have the codification, but it demonstrates that actually, if you receive your board packs, you need to know what's in them and you need to read them.
Next slide. So, Debbie, the law, is it still relevant to the codified duties today?
The answer is yes. So we have the codification under the Companies Act 2006, but essentially when interpreting whether a director has breached those duties, we will still have regard to the case law.
Okay, and that brings me on to the codification. So as we can see, there are 7 codified duties on the slide, and these are introduced at section 170 of the Companies Act. There are 7, and we like to remember them in groups of 2. The first group includes section 171 right through to section 174, and we call this duties to do with managing the company. And the remaining 3 duties, 175 to 177, includes duties for directors to be transparent and honest. Okay, looking at the first 2 in our group to do with managing the company. Section 171, the duty to act within the powers of the company. Now, the Articles of Association would be the Constitution. And if you have a company that was incorporated before the Companies Act 2006, you'd have a Memorandum of Association, and it'd be there that you'd have the objects and powers of the director. It'd be here, your Constitution, that a director would be able to find what he can and cannot do, what his powers are restricted to. So that would be the go-to instruction to a director. If there is a shareholders agreement, this needs to be considered too.
So Karina, what about companies that still have articles under the Companies Act 1985? Are they still relevant?
Yeah, so the memorandum would be in the 1985 Constitution, and it would be a good idea for you to check that you are not in breach. It may be that inadvertently a director is unaware of the restrictions of his powers within the memorandum. It's a good idea to update so that you fall within the new Act and have no restriction on your powers. You have general powers, and Jordan's Corporate Law can offer that service to you.
Thank you.
So section 172, duties to promote the success of the company. We will look at that in more detail, and there is a non-exhaustive list that is set out there. And Debbie, as I said, we'll touch on this later. So there now we're looking at the last 2 in our group of the transparency of directors.
We're still on the aren't we still on the management? Section 173.
Yes. So section 173, duty to exercise independent judgment. So here we've got their different hats Now, as a director, it may be that you are a director of more than one company, and when you're in a board meeting for one of your companies, you should not be making decisions considering the other companies. Like we said in the case study that Debbie outlined in Deeks and Hind, there were two companies and they were doing their best to succeed in the second company. However, they should have been mindful of their directorship in the first company. So we advise here to bear in mind when you're sat in a board meeting, make sure that your decisions are based on the benefit of that particular company. And as I said, if you've got different directorships, you should lay them aside and focus on the company that you're making decisions on. So section 174 there, duty to exercise reasonable care and skill and diligence. There is two tests here. There's the objective test at A, a person carrying out functions of a director in relation to the company, and B, in relation to general knowledge, skill and experience that the director actually has. So A being the objective test, that looks at what is reasonable, what would a person generally do, and B is to do with what is specific to that individual. So for example, if you are a director that has financial qualifications, when looking at whether you've exercised reasonable care and skill, that qualification will be taken into account. So the test is higher if you do have certain skills. Debbie, moving to you.
So turning to the three remaining codified duties, as Karina noted, these are duties of transparency and honesty. This is the way we like to remember them. So essentially at section 175, a duty to avoid conflict of interest. That is where a director must avoid situations which have or can have a direct or indirect interest that conflicts or may conflict with the company's interest. And essentially how this may resonate itself is if there are contracts or suppliers that a director may have more than a commercial relationship with, or might have known about in a different guise, then the best position to be in here is to declare any conflict or even potential conflict, disclose it to the board so that the board can be informed and to make the decision as to whether that particular director may or may not be involved in that element of the business. And of course you have regard to your articles of association at that in this regard as well, because that will give you guidance as to whether a director may or may not vote. But essentially this is to bring out any potential conflicts that may arise. Section 176, duty not to accept benefits from third parties. These benefits conferred by the company or through a service contract, they're excluded. And we also have the overlay of the Bribery Act 2010 to think about. And essentially this duty is to ensure, again, transparency and honesty amongst the board, so that everybody can know and understand if there are any conflicting areas that the board needs to be mindful of. Policies and procedures that would help here to make sure this happens is, for instance, a gifts and hospitality policy, any form of anti-bribery or corruption policy, and other elements of policies and procedures where there is the requirement to notify through the business. And section 177, a duty to declare interest in proposed transactions or arrangements with the company. So this is, if you like, the final hurdle of transparency, because essentially if you're a director and you're working on a contractual arrangement, you should be, and you feel there's a conflict there or there's an interest there, you should be declaring this in any event. But section 177 tends to be used where we're at the final hurdle and need to make a decision or a board resolution. So the declaration is evidenced in the board minutes, but it's essentially a repeating declaration because the interest should have been picked up prior to that point. So that's where in your board minutes you generally do see this declaration, especially in smaller companies where you've got a shareholder who's also a director.
Okay, Toby, before we move on to overlap with other provisions, what about shadow directors?
Shadow directors, good call. A shadow director, just to give you an insight into what that really means, is it's somebody who essentially is not a statutory director, but for all intents and purposes is involved in the decision making of the company, in quotes unquote the shadow. So essentially, Karina, the new 2006 Act and with the overlay of the SPIA means that shadow directors are duty bound to comply with all of the duties, even if they may not think they should.
Yeah. Thank you. Yes, yeah. Yes it does. Okay, so moving on to overlap with other provisions. So as well as the 7 codified duties we've gone through, there are other things that the directors have to be mindful of. So filing requirements. So your accounts and your confirmation statements, these should be filed. Now it may be that as a director, you're not the individual that does the filing and there's somebody else that you employ to do that. However, you are the director and you should make sure that these are done so that you don't fall foul of meeting those annual filings and you don't receive a letter from Companies House chasing you for those filings.
So is it Companies House, Karina, where they need to be?
That's right. At Companies House, your accounts and your confirmation statements, as they're now known, would be filed. Okay, so other transactions that concern directors are listed in section 188 to 230, and here there are requirements for these transactions to be approved by members, and we've listed just some examples of them there. So where there's a service agreement, that would need to be approved by members. Where there's substantial property transactions, again you need the approval of a member, and certain loans to directors, you also need member approval. So directors have to be mindful that if any of these transactions are happening, there is written evidence that it's been approved by the members of the company. Okay, other provisions there which concern directors is the Insolvency Act provisions. Now, there's 2 there that we've actually put down there: wrongful trading and fraudulent trading. Now, these are found in the Insolvency Act 1986. Now, wrongful trading concerns where a company is going into insolvency liquidation and is before the commencing of winding up. And a director would have known or ought to have concluded that there was no reasonable prospect that company could avoid being in this situation. And that director would be required by the court on the application of a liquidator to contribute. The court, however, wouldn't make a wrongful trading order to a director if the director can show they took every step to minimise the potential loss to the company's creditors. And legal advice should be taken immediately. That's our tip for a director. If you feel or can see that you're going to enter into any financial difficulty, or you suspect that the company is on its way to becoming insolvent, you should seek advice. You should seek advice from a financial advisor or an insolvency expert to avoid wrongful trading. It could be necessary that the company ceases trading. And fraudulent trading, which is found at Section 213 of the Insolvency Act 1986 and also Section 993 of the Companies Act. So here, this is where a company is in business and has been carrying on business with the intention to defraud creditors of the company, and a liquidator will apply to the court to obtain a contribution from a director who knowingly carried on business in this manner.
So what is the difference, Karina, between fraudulent and wrongful trading?
Okay, so the difference is dishonesty. So with fraudulent trading, dishonesty is required. So it has to actually be proven that the director has a real knowledge that he was doing business with the intention of defrauding creditors. So where he actually took positive steps to continue to trade, continue to incur debts, and he was aware that he'd been able to pay creditors.
So that's a much higher burden of proof.
It is.
Yeah.
It
Okay.
is.
Thank you.
Okay, so if you are found to be in breach of your duties, there are sanctions. So there are civil penalties for the breaches to Section 171 to 177, and shareholders as well can bring an action, and we call it a derivative action. There are criminal penalties where there's been a breach of Section 182, and Debbie did touch on this when talking about 177, a declaration of interest to existing transactions. And then there's penalties for what I've explained, where there's been fraudulent trading. Criminal penalties obviously could be a custodial sentence or a fine or both. So it's quite a high penalty for breaching your duty. A further thing that could be done by a court is an order to disqualify you as a director. Now, with a director's disqualification, you can be at the maximum disqualified for 15 years for setting up a company. So you wouldn't be able to set up a company, you wouldn't be able to even be involved in a company. So it's quite a high sanction for breaching a duty. Another thing that a director could do, rather than have a disqualification, is make an undertaking that they would for so many years not participate or form any company for a period of time, and then once that period of time has passed, they would then be able to start a new company or be involved in a company.
And Karina, is it the insolvency service that gets involved in those?
It is, so it's in a governmental
powers.
department.
Yeah. Okay, thank you.
And then further, your own members, your own shareholders could remove you, and the procedure is set out in Section 168 of the Companies Act 2006.
Thank you. So now we know where our duties are. What do we think are the key elements to effectively manage and protect your business? So at the start of this thinking process, obviously from a commercial perspective, you'll be looking at a business strategy, business plan, and putting that in place and measuring against it. But behind that and integral to that is a strong corporate governance framework. Also maintaining good communication and relations with key stakeholders. So that's not only your shareholders, but your employees, your suppliers, your creditors, and many more. If you're in a regulated area, then your regulator is also key. And integral to this is knowing your duties, hence the training today. And the most effective way for a director to manage and protect their business from a compliance perspective is to ensure that those duties are known and to demonstrate that those duties have been applied when decisions are made. So those decisions are informed decisions. And on this slide, we've also put details around, okay, we're looking at this not only from small businesses, growing businesses, large businesses. Every director has duties, but directors of listed entities, as you can see, have not only duties codified under the Companies Act, but also duties in relation to the listing rules, transparency rules, AIM rules, Financial Services and Markets Act, Financial Services Act, Market Abuse Regs, and so on and so forth. So it is wholly important that a director is protected and has the knowledge in this area. So how to build a strong corporate governance and stakeholder trust. Some of the elements that we advise our clients around are set out here, but essentially what we do push is that you need to ensure that all board members, so as a director yourself, yes, you need to feel you are fit and proper for the role that you are undertaking, but also that you've been trained in this area, and sitting around a table with others to ensure that all board members are fit for purpose and are effective around your board and are trained, because that will help you in your role. Build a corporate governance framework as the business evolves. So not every framework needs to be fully fledged, robust. As you grow, as your business starts and grows, you need to be checking and measuring your corporate governance framework as you go. Have a clear code of conduct, a clear delegation of authority, business policies and procedures. Hold regular board meetings, committee meetings, have clear terms of reference for those committees. Board packs, ensure you've got the board packs that you need, not too much, not too little, and ensure that those reporting requirements happen with a timetable that allows directors to receive those reports and read those reports in good time before the meeting. Record accurate minutes of the discussions and promptly release your action points. Ensure that best practice compliance is followed and raise any concerns. That every director is in a position to be able to help and maintain best practice. Maintain good lines of communication with creditors, suppliers, stakeholders, including the employees. And if you are in a regulated sector, then the regulator. Ensure that the board and shareholders have access to up-to-date financial information at all times, so that everybody knows where the business is at any given moment. And I've just added there a clear strategy business plan with regular checks and measures that from a commercial aspect, obviously that's wholly important. Now, bearing that in mind, as Karina said earlier in the piece, we are looking at Section 172 in particular as a codified duty. This duty has come up, has proposed reforms, and for good reason. Essentially, the duty is that a director of a company must act in the way he considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole, and in doing so have regard to, and then it lists from A to F the elements that the director must think about as they go through their decision making. So the decision has need to understand what the likely consequences will be in the long term for the business. Think about the employees, think about the relationships with the suppliers and the community environment, and looking at the regulatory and business conduct and reputation and the need to act fairly. So that's a list that essentially is designed to give a rounded and informed decision. And when we look at this, we think about, say, a major factory closure in a village that's been long-standing, and thinking about actually if it's loss-making, how do you make the decision whether you keep that factory open or not? That's an example that we tend to use. But essentially, there's been some failures in the past year or two, which has brought this section into the forefront of corporate governance minds. So I'll pass over to Karina to tell you a little more.
Yes, Debbie, there have been a number of proposals and reforms. I'm just going to go through each of these. Each of these are set to begin on or after the 1st of January 2019. So the first there is the Companies Miscellaneous Reporting Regulations 2018. So they were laid and they're subject to approval. And here we can see what the new reporting requirements are. So bearing in mind what Debbie has just touched on, that list that's set out in section 172 of the Act, the statement in the strategic report has to show that directors have had regard to that list. Now, the companies that this applies to are companies that meet 2 out of the 3 criteria. So they have a turnover of more than 36 million, a balance sheet of a total of more than 18 million, and more than 250 employees. So the next statement that has to be in the report is directors summarising how they've engaged their suppliers, customers and others in the business relationship with the company. And again, it's the same criteria there for companies to do this particular statement in the report. And then thirdly there, in the director's report, about the corporate governance arrangements that have been applied to the company. And the criteria there is different. Companies will either have 2,000 more global employees or a turnover of 200 million globally and a balance sheet of 2 billion globally. And we're just pointing out some exemptions here. So companies that are listed won't have to do this, and companies that are community interest companies or charities are also exempt. Okay, so the other reform that's going to be introduced on or after the 1st of January 2019 is what we're summarising as the Wates Code, but it's actually in full the Wates Corporate Governance Code. Now, there was a consultation in June this year, and it is actually the first corporate governance code for large private companies. Now, to meet the criteria of a large private company, you would either have to satisfy both of the conditions or either of them. So just going through the list there, more than 2,000 employees globally, a turnover of more than 200 million and a balance sheet of more than 2 billion. And as I said, it is subject to approval, but it is likely that this will happen at the beginning of January next year. Okay, so the new UK Corporate Governance Code, we're abbreviating it as 2018 Code. The 2018 Code, this applies to listed companies on the stock exchange and for accounting periods on or after the 1st of January 2019. And what this is focusing on is improving relationships with stakeholders, and in particular, the workforce throughout So what we're looking at there is appointing a director from the workforce, a formal workforce advisory panel, and/or a designated non-executive director. There's a more demanding criteria for remuneration policies and practices, and this includes better linkage between policy, strategy, long-term value and workforce remuneration. And these things seem to be neglected, but they're actually at the forefront now and should be at the forefront of directors' minds. So with those reforms in mind, just some case examples here. Just familiarise yourself with the facts. So BHS, it was sold by Sir Philip Green to Dominic Chappell, and prior to being sold, it was operating at a loss for about 7 years, and they entered into administration. Okay, BHS's downfall was loss of relevancy in the marketplace, and there was just a sharp fall in demand. Also, there was poor management of the pension scheme, and the pension pot was in a deficit of quite a high figure of 571 million, and that was at the time of entering into administration. So the assets included the high street stores, so those needed to be sold off to try and avoid insolvency, and they were searching for a buyer, but as we know, no such buyer was found. And then in late August, all the high street stores were closed, there was liquidation, and all in all, 11,000 jobs were lost. So that is an example of how, unfortunately, things weren't handled correctly. So Carillion, here in this case, there were 450 government contracts, and these included education and defence and justice. And there was also a major construction project which spanned the country, and this included HS2 high-speed railway. Now, they were making risky business decisions, and there was failure to pay monies to the Middle East. So there was delays in payments, and due to loss of money on large contracts and the debts, unfortunately, the company collapsed. And there was also scandal with around bosses being paid, even though it was in dire straits. And then CityLink was owned by Rentokil, Rentokil is a listed company. So their history is of acquiring, trying to manage expenses, but not doing a good job. And then there were losses and ceased to trade in 2015.
So with those failures, Karina, really it's the long-term value that so in looking at Section 172, that first point, it's about looking to the future and the long-term value, and creditors and employees.
That's right. Yeah. And this moves me nicely on to the next slide. Government's reforms and proposals. So due to those relevant cases that I've just explained, the government has launched plans to safeguard workers, pensions and small suppliers for when a company goes into insolvency. So under these new powers, the Insolvency Service, which we mentioned, is a governmental department. They are going to be given powers to fine directors or even disqualify them. The Investment Association will be asked to investigate to see if any action is needed to ensure that companies are giving their shareholders an annual vote on dividends. This is something that has been neglected, and the government is now addressing this as well. So directors will face investigation if they try to shy away from paying debts to their own staff and creditors, and they will be held accountable where they fail to stay on top of their obligations. So the government will be introducing new measures to give financially viable companies more time to rescue their business. Debbie, over to you.
So here on this slide, what we've looked to provide is practical considerations if you are a new director or if you are an existing director. So essentially, these are just questions to ask yourself. Do you know the codified duties? If you are an existing director, are you checking and measuring whether you're complying with those codified duties? Is there a particular governance code? So the first thing you need to find out as a new director is the company that you are being appointed to, does it comply with a particular governance code? Just because, so if it's a listed entity, it will. Whether it's on the main market or AIM, there will be a governance code that it's complying with. But even if it's non-listed, companies can choose to comply with the UK Corporate Governance Code, the QCA code, or others to provide best practice governance. So do check that. Do you know what's in the articles? If you don't, find out. Are there other constitutional documents that you need to know about where there may be restrictions on your or reserved matters that you need to take to your shareholders? So ask if there's a shareholders agreement or investment agreement of any description that you need to be mindful of. What does your service agreement say? What are you being asked to do over and above what would be a statutory director post? Do you have a particular skill? Would you fall under 174 with the subjective objective test? Are you within a particular sector? And if so, do you feel the company is complying with the regulatory requirements? Is the company holding regular board meetings? Are you happy with the corporate governance framework that you're seeing in front of you or you're being provided with? Are there policies and procedures? Again, have you seen them? Do you agree with them? Do you feel there's anything missing? There is nothing to stop you as a director. In fact, it's a duty to make sure that you're happy with the corporate governance framework and that it fits with the requirements of the company.
Okay, so that brings us to our opening picture, our image of staying on top of your duties. Debbie.
Karina, is that Tom Cruise on the right-hand side of the...
I'm not sure if he's scaling the building, but as a director, you should be always on top of your, of your duties.
So that brings us to the close of our slides, and really I'd like to open it to the floor for any questions. So I think we have one question coming through.
Yeah, it's just come into my inbox. What is delegation of authority matrix?
Yes, so that's very helpful from a corporate governance perspective, especially if you have a lot of board members or even just one or two board members, to ensure that everybody knows who has the authority to engage on certain matters and who needs to sign off on any decision making. So, for instance, if you are a company that goes for very large contracts, you can have a delegation of authority to be below a statutory director level for negotiation of, say, a contract that's around 500,000, but it needs to be signed by one director and a senior manager, or if it goes to a certain level of 1.2 million, then it needs to be brought to board level and signed by two directors. If there's an HR element to it, then you may want your HR director to sign off. If there's a regulatory aspect to it, then you may want your compliance officer to sign off. So it's a way of ensuring that the subject matter experts and the importance is taken into account when making allowing authority.
Okay, thank you, Debbie. And another question that's come in is, should I be asking my sales director to report on events that he's going to or inviting people to?
Yes. In short, yes, especially if you don't know what your sales director is doing, and also if there's a lot of events going on, it's understanding that, and getting that transparency, and even your reporting requirements. You want to know that what that individual is doing is helping the business, and in particular it'd be interesting to see whether that sales director is a statutory director,
Yeah.
or whether it's a director in name only.
Okay.
So I think unless there's any more questions at this point, we will close the webinar, and I would like to thank you all for your time.